In this video we are going to cover chapter 1 of BNSS, and section 1 to 5 are there in chapter 1. Chapter 1 is preliminary, and so we are going to cover those provisions. I have not covered section 2, which is the definition clause, and we will cover the definitions with the relevant provisions where the definitions are, the terms there in the definitions are used. So we are going to cover 1 to 5 except section 2. So the act is Bharatiya Nagrik Suraksha Sanhita 2023. It is act number 46 of 2023. President's assent was received on 25th December 2023, whereas the enforcement is 1st July 2024. It provides 39 chapters, 531 provisions and 2 schedules. So you see the number of chapters and the provisions both are increased in comparison to the earlier act, which used to provide only 484 provisions, CRPC. So now in brief, what are the object of this act, why this act was drafted and CRPC has been repealed. So the number one reason is given as it was a colonial era criminal law, and it was made by the Britishers. So I don't find any reason, any logic in this statement. It was a Britishers law, the CRPC, IPC and the Evidence Act. And the reason is that the earlier CRPC was prepared in 1898, and then 1973 law was almost the same as the law, as the provisions were given in 1898 CRPC Act, and this almost same law was adopted in 1973. And even if you see the current law, BNSS, it is also the same provisions. The 90%, more than 90% is the copy paste. Some been argued that we are getting rid of that. Is not the right statement, because still the law is 90% same as it was at that time. So this is a false propaganda. Now number 2, CRPC was a colonial law made by the Britishers in 1898 and reformed in 1973, as I said. This is the one of the changes we see. It incorporates the provisions for use of technology, digital evidence, video trials, electronic communication. So now you can see the provisions which are in tune with the use of technology. Then time limits are specified for a speedy investigation. This is for the speedy disposal of the cases, speedy justice to the citizens of India. So it provides now the trial, investigation and judgments. There are certain the deadline for those things. So for example, charge sheet, it is 90 days provided there, and for judgment it's 45 days, etc. And there are so many other the deadlines are now introduced for different procedures provided in the act. So this was the basic these are the basic reasons, the object. But I have also prepared 2-3 videos earlier in the present playlist. You can watch what changes are directly, what key changes are made in CRPC while this BNSS was drafted. So you can watch those videos. Now coming to the provision, and it is chapter 1 preliminary. Section 1 is just about the act, name of the act, extent and commencement. So this act is called Bharatiya Nagrik Suraksha Sanhita 2023, and subsection 2 says the provisions of this Sanhita other than those relating to chapter 9, 11 and 12 shall not apply. So it says that other than 9, 11 and 12 shall not accept these chapters. The other provisions shall not apply to Nagaland and to tribal areas, but the concerned state government. So the state of Nagaland government or the tribal areas where the provisions are not going to be applied, and those state governments may by notification apply such provisions or any of them to whole or part of the state of Nagaland or such tribal areas, as may be with modification, incidental or supplemental consequential modification in the notification. Explanation provides tribal area, and it means that the territories which immediately before 21st January 1972 were included in tribal areas of Assam, as referred in para 20 of the 6th schedule, and other than those within the limits of municipality of Shillong. So except Shillong, the tribal areas which were included in Assam before 21st January 1972 is are the tribal areas which are meant in this provision, and it is provided in para 20 of the 6th schedule of the Constitution. So the the provision simply says that the provisions of Sanhita shall apply throughout the territory of India except the state of Nagaland and some tribal areas, but chapter 9, 11, 12 will apply, and also the state of Nagaland and the state of wherever these tribal areas are situated, those state governments can decide to give the provisions of this code extension to and allow these provisions to be commenced to those territories. So this is section 1. Now section 3 provides construction of references. Subsection 1 says, unless the context otherwise requires any reference in any law to magistrate without any qualifying words, magistrate of first class or magistrate of the second class shall in relation to any area be construed as reference to a judicial magistrate of first class and judicial magistrate of second class. So it means that JMFC or JMSC exercising jurisdiction in that particular area, and only the magistrate exercising jurisdiction in area where the reference has been made to any of these authorities, only those judicial magistrate first class or second class are to be approached for anything under their jurisdiction. Now subsection 2 says, where under any law other than this Sanhita, the functions exercisable by a magistrate relate to which involve the appreciation or shifting of evidence or the formulation of any decision which exposes any person to any punishment or penalty, detention in custody, pending investigation, inquiry or trial, or would have the effect of sending him for trial before any court, they shall, subject to the provisions of this Sanhita, be exercisable by the judicial magistrate. So subsection 2 clause A makes it very clear, in any other act other than this Sanhita, wherever the act involves the appreciation or shifting of evidence or the formulation of any decision which exposes any person to any punishment, penalty, detention in custody, in pending investigation, inquiry or trial, all these things shall be done by a judicial magistrate and not by executive magistrate. So wherever the magistrate term is used in any other act and any of these act to be performed, it shall be performed only by judicial magistrate as per clause A. Now subsection 2 clause B says, any act which are administrative or executive in nature, such as the granting of license, the suspension or cancellation of license, sanctioning a prosecution or withdrawing from prosecution, they shall be subject to the provisions of clause A, be exercisable by any executive magistrate. So anything which is administrative in nature, executive in nature, and with regard to granting of license or its suspension or cancellation, or with regard to sanctioning a prosecution or withdrawing a prosecution, any of these acts are to be done by and only by executive magistrate, not by a judicial magistrate, unless subject to provisions of clause A, as it says. Now section 4 of BNSS says, trial of offences under Bharatiya Nyaya Sanhita 2023 and other laws. So subsection 1 says, all offences under the Bharatiya Nyaya Sanhita shall be investigated, inquired into, tried and otherwise dealt with according to the provisions hereinafter contained. So it talks about BNS only, which was earlier IPC, and it says that a trial under its investigation, any offences investigation, inquiry or trial shall be done according to the provisions of this act, and subsection 1 is specifically about BNS. Now subsection 2 says, all offences under any other law shall be investigated. So other law means other than BNS, shall be investigated, inquired into, tried and otherwise dealt with according to the same provisions, but subject to any enactment for the time being in force, regulating the manner or place of investigation, inquiring into, trying or otherwise dealing with such offences. So it says that the same provisions of this act, this code, shall apply to other offences, all offences under any other law. as uh, they apply in cases in case of trial under BNS, but it's also imposes a rider that subject to any enactment for the time being in force, regulating the manner or place of investigating, inquiring into, trying or otherwise dealing with such offences. So it says that if there is any enactment with regard to how the offence under any other law is to be investigated, inquired, or where is to be investigated or inquired, that enactment shall be having an overriding effect on the procedure provided under this code. So, for example, Prevention of Gambling Act 1887. This act provides how the investigation trial is to be conducted, and it has its own procedure. So, here BNSS shall not apply, its provisions shall not apply when it is an offence under Gambling Act, because it has its own procedure provided under the act, and the court shall follow that procedure only. Now section 4 does not apply on departmental inquiry or contempt of court proceedings. It obviously came through the judgments of Supreme Court and High Court, and according to those judgments, departmental inquiry, which means the provisions of CRPC earlier, now BNSS, are not attracted whenever the departmental inquiries are conducted against any person, and same with the contempt of court proceedings. Now I have reproduced some two judgments for section 4, and it is State of West Bengal versus Salap Service Station, AIR 1994 SC 1413. So issue was whether procedure under CRPC applies to offence under other statutes. So Supreme Court held that CRPC applies to offences under other laws unless the statute specifically provides a separate procedure. Thus, unless the special law is expressly or impliedly inconsistent with CRPC, the court shall apply. So it says whenever the special laws are there for the investigation and trial of the offences provided in the special laws, and if there is any inconsistent provision with the provisions of CRPC, now BNSS, the provisions of those special laws shall apply. But where there is no law specifically provided, then CRPC, the BNSS shall apply. So if the special law is silent about it, the provisions of CRPC, BNSS shall apply. Now the another case, Directorate of Enforcement versus Deepak Mahajan 1994 3 SCC 440. The issue was whether provisions of CRPC apply to arrest under special statutes like FERA and Customs Act. So the court says section 4 subsection 2 of CRPC applicable even to the special laws unless they contain a contrary procedure. Thus provisions relating to arrest and production under CRPC can be used even in cases under FERA and Customs Act. Now section 5 provides saving, and it says nothing contained in this Sanhita in the absence of a specific provision to the contrary affect any special or local law for the time being in force, or any special jurisdiction or power conferred, or any special form of procedure prescribed by any other law for the time being in force. It says that special law or local law shall prevail over this Sanhita, or any special jurisdiction provided under those laws shall prevail jurisdiction provided under this Sanhita, or any special form of procedure provided under those special acts shall prevail over the provisions of this Sanhita. So this is section 5. Now in this judgment, Motiram Deka versus General Manager any Frontier Railway, it was held that when two laws apply to the same situation, the special law shall prevail over general law, and this is what section 5 says, and this principle applied in cases where NDPS, PMLA, these special laws provide their own jurisdiction, their own special procedures. So whenever the provisions and the jurisdiction of offences committed under those acts, the jurisdiction and the procedure provided under these special laws shall prevail over the provisions of BNSS. So I hope you understood these provisions. Thanks for watching.